But the big issue in sobriety roadblocks is that they are without cause. Obviously, you stop everybody. And without probable cause or reasonable suspicion, can you stop a car? And that was the big thing.
Were they doing this in Michigan? Because I've got to tell you, I've never seen in my life a sobriety roadblock in Michigan.
I can take some credit for that, because after losing this in the United States Supreme Court, we came back to Michigan and argued the Michigan Constitution before the Michigan Supreme Court, and I won. So
there is like it's like a good movie ending, There's a happy ending. All right, everyone, welcome to Cases Gone Wild with me, your host, Jon Marko, brought to you by Marko Law. We have a great show for you today. You're not going to want to miss this show with one of the appellate gurus in the entire country. Mark Granzotto is here to be with us today. On this show, we talk about the craziest, wildest cases that you don't believe, that you can't believe, that you won't believe, but you should believe because they're real. And we have some really good cases for you today. We're going to talk about the Supreme Court of the United States. We're going to talk about the Michigan Supreme Court, all things appellate, which is a lawyer word for all the appeals, all the appeals. If you like the show, make sure you give us a thumbs up or like it or whatever they do nowadays, and share it with your friends and family. And thanks for being here. Mark, thanks for being on the show. Good to see you, buddy. Good to see you.
Very nice to be here.
Good friend, Mark. I've known you a long time. You've helped me on some of my appeals that needed a lot of help, especially earlier on in my career. You graduated from Wayne State in 1978. You clerked for a federal judge, which is always a prestigious thing to do. And then this is what's crazy, man. You have been counsel of record in over 1,500 cases at the Michigan Court of Appeals. At the Michigan Supreme Court, over 600 cases. And is this true? Somebody told me that you have actually argued at the Michigan Supreme Court like around 75 times?
That's correct.
That has to be more than anybody in Michigan.
Well, I don't know if it's in the history of Michigan, but I've asked the Michigan Supreme Court Historical Society to look into it. But
what did they say?
They only did a 20-year period in this century. Unfortunately, I go back to the last century. But I had the most for this 20-year period from about 2003 to 2023. So.
All right, we're going to send them a copy of the show, and they're going to have to get us updated numbers for you.
Yeah, they've identified themselves as my fan club.
Well, that's cool. I mean, you are truly like the top appellate attorney. The only other appellate attorney on our side that does as much as you that I can think of is Mark Bendour.
Yes,
who's a
Mark,
great,
very good lawyer.
Yeah,
but he's also talented enough that he can do trial level work. A talent I never acquired.
Well, as people tell me, you got to stay in the lane, right? You also argued before the United States Supreme Court, which is probably the pinnacle or ultimate honor of a appellate attorney, I would imagine.
Yes, I was unfortunately quite young. I was in my 30s at the time. It was a traumatic experience for me, but I'm glad I did it. I've actually been to the Supreme Court, U.S. Supreme Court, at counsel tables 3 times. The other 2 times I didn't argue the case, but I was on the brief. So once arguing was enough for me.
Yeah. Well, that's more than most lawyers in their entire career.
Mm-hmm.
So tell us about, and let's show a picture. You have a picture, I think, so we can show our viewers a picture. What argument was this picture from that our viewers are seeing?
This was the argument that I did. The case was Michigan Department of State Police versus SITS. It's a very, very important, perhaps too important to have me as a lawyer. But
what year was this case?
1990 it got to the Supreme Court of the United States.
So who was the Chief Justice? Was that Rehnquist? then?
Rehnquist.
Oh, boy.
Yes.
All right.
And the sad news at the end of the story is Rehnquist wrote the opinion, which meant I lost.
That's a little foreshadowing right there, right? It's a criminal defense
But
case.
it was about sobriety roadblocks and the constitutionality of sobriety roadblocks.
So these are sobriety roadblocks, if our listeners don't know. That's where, like, the cops just set up a roadblock and stop everybody no matter what?
Correct. And it obviously it's the Fourth Amendment issue, and I have to confess I'm not an expert on the Fourth Amendment. I was a limited expert to do this case. But the big issue in sobriety roadblocks is that they are without cause. Obviously, they stop everybody. And without probable cause or reasonable suspicion, can you stop a car? And that was the big thing.
Where were they doing that? Were they doing this in Michigan? Because I've got to tell you, I've never seen in my life a sobriety roadblock in Michigan.
And the reason you've never seen it in Michigan is I can take some credit for that, because after losing this in the United States Supreme Court, we came back to Michigan and argued the Michigan Constitution before the Michigan Supreme Court, and I won. So
there is like it's like a good movie ending, There's a happy ending.
Yes, well, only in Michigan. I've told other people I was 1-49. I won one state and I lost the other 49. But
so were they doing this a lot before?
Well,
I mean,
this is an interesting part of the story for me, because it was an ACLU case, and we actually got the complaint and the challenge ready, but we didn't get it ready before the first time that they did it in Michigan. So I think it was in perhaps Genesee County or something like that. They did the first sobriety roadblock in Michigan. The following week, we filed a case in Wayne County. It was very, very unusual in my practice, because I was part of the trial team. I was obviously there to do the legal work, but two experienced, very good trial lawyers were with me. Bill Gage, I don't know if remember Bill, and Deb Gordon.
Oh, yeah.
Two very good trial lawyers. And I was supposed to
I've
do
went
the
up
legal
against Deb before. She's a very tenacious lawyer.
Very tenacious. But what was unusual for me was I was actually involved in the trial and putting together the evidentiary hearing, challenging it. And we won in the circuit court. And we went to the Michigan Court of Appeals, and we won. The Michigan Supreme Court didn't want to hear the case, and the Attorney General applied for cert, and they granted cert.
So you took it to the trial court, said it's unconstitutional. Court of Appeals said unconstitutional. Supreme Court says we don't want to deal with this,
right?
Because they can do that, right?
Yeah,
they don't. The Supreme Court doesn't have to take everything.
No. In fact, they take very few cases, 5% perhaps.
So the state, who was the Attorney General who was driving this train on this, by the way?
It was a nice guy, Tom Casey at the time. I think he was Solicitor General. He was the attorney involved. But it was Frank Kelly, if you remember Frank
Very
Kelly.
famous name in Michigan,
Frank Kelly. Yeah, so we went to the Supreme Court granted cert. I spent hundreds of hours working on the brief. We went, I remember we had to go, because it was an ACLU case, we had to go travel to New York to do a mock argument before a panel from the national ACLU. And we met Steve Shapiro, who was a brilliant
very famous
person,
lawyer.
Very familiar with how the Supreme Court operates. And he gave me tips on the how to do what was going to happen at the oral argument. And one of the things I still remember he told me is the two people who would be most likely to vote for you don't usually participate in oral argument, and that's William Brennan and Thurgood Marshall. Okay, so what happened is the substance of the constitutional challenge was obviously the Fourth Amendment, and part of the Fourth Amendment calculus that was in play was whether sobriety roadblocks worked. Okay, in other words, efficacy. Did this intrusion, this warrantless, suspicionless intrusion, did it really work? And the good news from our perspective...
And for our viewers, Fourth Amendment, who aren't lawyers, is, among other things, illegal searches and seizures,
Correct.
right? The police
Correct.
can't enter your home and start searching through your papers or do anything else without a warrant or special circumstances.
That's correct. And there is no question that stopping the car, interviewing you, making you roll down your window is a seizure. So it was
These
not
had
a
to be
question.
unpopular. I mean, I would imagine, or were they? I mean, was it a different time? I mean, I just don't see this flying as a practical matter, at least on a popularity opinion. It seems like it would be very unpopular.
Interesting question, because after my loss, it's legal in 49 states, but I don't read much about it. I don't know if it's used. And the reason perhaps it's not used is something we did prove in the case, and that is it's not an effective way of arresting people for drunk driving.
Why not? I mean, it seems to me like if you're wasted and they roll down your window, they see a bottle of beer on your dash or something.
Yes, but the fact is you had to do a sobriety roadblock, you had to concentrate 10 or 12 or whatever number of officers in one location, and people had to pass it. Okay, we could easily prove that you could stop a lot more people by putting those 10 or 12 guys around bars.
Yeah.
And if you did that, you'd stop a lot more people from drunk driving.
Yeah,
okay.
yeah.
So the fact is we could easily prove in terms of the efficacy that it doesn't arrest more people. But the defendant's response was it deters people. So deterrence became their principal argument.
In other words, if they know there's going to be roadblocks,
Yes.
they're not going to do it.
This
was before we had Uber and stuff, which for like our younger viewers, it's like, what are you talking about? Like, but I remember growing up, there was, and I'm a lot younger, right? But I remember a lot of people would drink and drive. It was just like part of what people would do. I mean, at different levels. And part of it was the convenience. You couldn't just go on your phone and get an Uber. You'd have to call a taxi on like a hotline, and then you'd have to wait like 45 minutes for a taxi to come and stuff.
Yeah. So the oral argument, we're in the oral argument, and I just wanted the oral argument to be over. I had
is that
not
bad?
Slept the night before.
Were you nervous?
I was incredibly nervous, and
was it intimidating?
We had like a two-part argument. One of which, the first part of which was based on a Scalia opinion, okay, that he had written something to do with drug testing, okay, and that was the first part of our argument. And the first question I get asked is by Scalia. He said, "This has nothing to do with the Von Raab case, does it?" And which, of course, destroyed our first argument before I was about 2 or 3 minutes into my argument. But I'm struggling through the argument. And the funny thing, it was not so funny at the time, I start talking about deterrence, okay, what the defendants were relying on, deterrence. And suddenly there's this gravelly voice that sort of fills the courtroom. And I was talking about that one night where they did a sobriety roadblock in Michigan, and this gravelly voice comes in. At first, I didn't know where it was coming from, but then I realized Thurgood Marshall is asking me a question, and the question he says to me is a question that would have been fantastic if he asked the other side, but instead he asked me. And he said, "Okay, counsel, how many people were deterred that night?" Okay. It would have been such a great question if he asked the Attorney General. Okay, because the answer, of course, is, "I don't know." But he asked me instead. And, of course, my answer was, "I don't know." And he said triumphantly, "I thought so." I couldn't believe it. Thurgood Marshall asked me a question, and it was a terrible question for me. And I answered it wrong. It's the one question in 40 years of practice I'd like to have back, because the answer should have been, I don't know, and neither does he.
Yeah. And Thurgood Marshall should have been like the advocate. You know, he was like a civil rights advocate, right? You know?
And I was being dragged out to this bank of microphones by the then executive director of the ACLU, Howard Simon.
After the hearing?
After the hearing. And I said to Howard, we came down here thinking we were going to lose 7-2, and we might lose 8-1. I thought it was bad. But
and so our listeners know, I mean, this was a bad bench for that type of case back then.
There's
I mean, this
question.
was, who was it, Rehnquist?
Scalia, O'Connor, White, and Kennedy, I think. That the ultimate vote was 5-1 to 3. It was the conservatives. Blackmun wrote a concurring opinion, but I did get 3 dissents. And one was by Brennan, one was by Stevens, but the other one was by Marshall, which when it came out completely deflated me, because when he asked me that question, and he was so pleased with my response, and it suddenly occurred to me at the end of the line, I was doing such a crummy job. He thought I was the Attorney General. So the final vote was not a complete vindication of my performance, I think.
Yeah. Well, that had to be exciting. Mark Bandor said you get like a little pen or something? Or
No,
like
you get a quill.
A quill.
You get a quill. So I have 3 quills in my desk in the office.
That's amazing. So you came back after you lost the case, and then you brought it in the state court?
Yes,
how does that even
work? Under the Michigan Constitution.
A different case, like a different client or something?
No. The exact same case, because in the original case, we had filed under both the United States and the Michigan Constitution. The original decision by the Circuit Court and then by the Court of Appeals was on the basis of the U.S. Constitution. So it had to be remanded for determination under the Michigan Constitution. And we won in the Court of Appeals on the on remand. And we went back, and this time the Michigan Supreme Court wanted to hear the case, because now it was an issue of Michigan law, important issue of Michigan law. And we went I argued again before the Michigan Supreme Court, and we won. It was in violation.
A long and windy road, but
probably 6-7 years. I think I counted at one time. During the course of these proceedings, I wrote for different purposes like 12 briefs during the course of this one case, 12 different briefs, mostly on appeal, obviously. But I did get one piece of vindication that a lot of lawyers, I don't think, can claim, and that is when we tried this case, these 2 really good trial attorneys, we were in like the 3rd day, they said, you haven't been doing anything, Mark. Why don't you take the next witness? So the next day, I'm doing something I really don't know how to do. I'm examining an expert they called in, I think, from Maryland, but I cross-examined their expert, and it got cited in Judge Stevens' opinion. So a cross-examination that this lowly appellate lawyer did got cited in the U.S. Supreme Court.
That had to be exciting, you know? Yeah. So how does that work? You tried the constitutionality at Roadblocks. Did you have a jury, or was it a judge?
No, it was just an evidentiary hearing before.
Okay, so you have like a little mini trial, and then a judge makes a decision.
Exactly.
That's interesting. Well, what other case? You said that you had some other cases before the United States Supreme Court.
Yes.
Something about what was the case that you were telling me about before we were getting ready this morning?
Yeah, the second case I handled in the U.S. Supreme Court was an interesting case of a constitutional right to appellate counsel. Okay.
So the right to, like, we know, like, if you're like charged with a crime, they give you a public defender, right?
That's
to
correct.
Like go to the trial.
Yes.
And is this about like they give you an attorney to do an appeal for like crime?
That's correct. And at the time, there were 2 U.S. Supreme Court cases on assigned appellate counsel. The one rule the Supreme Court had ruled that you have a right to an assigned counsel where you have a first appeal of right. In other words,
So
they
like
had
you're
to hear-
convicted of murder, you get an appeal. Does the state have to give you a
Yes.
lawyer then? Okay.
That's a constitutional right. The second case, they decided there was no right. And that second case was a situation in which you had a second appeal, but not as of right. In other words, by leave, like the Michigan Supreme Court is, by leave. So you had these two cases. Michigan passed a law which applied only to guilty pleas. And what they said in this law was you don't have an appeal, a first appeal as of right in a guilty plea. You had to apply for leave. But they also said you don't get counsel. So we decided we were going to challenge this law.
So Michigan said if you plead guilty, like you don't go to trial, like, you know, you're charged with whatever, murder, and you say, all right, I plead guilty, you do not get an automatic right to appeal.
That's correct. And you don't get, according to the Michigan law, you don't get an attorney to help you.
So you're kind of screwed then,
That's correct.
right? I mean, why? And then would they do it to like cut down on the appeals because they didn't want as many appeals?
Yes.
Yeah.
So the ACLU was going to challenge this new law, and the challenge was you had to have a right to counsel in this application for leave because it was the first appeal. So what we had was a case that's like right between two U.S. Supreme Court cases, right between them. And we thought from a very early stage, this is a case that could reach the U.S. Supreme Court.
Did any other states have similar laws like this?
Not that I know of. Okay, so I was asked to work on this case, and I represented the plaintiffs, but we had one really major problem in the case, and that is we couldn't have, as one of our clients, a defendant, okay, because we had to have, in order to have a defendant, they had to be, number one, unrepresented, and they had to preserve the constitutional issue on their own, okay.
So you had to, in order to appeal this is so crazy, so that you had to go out and find somebody who did not have a lawyer, who pled guilty, right?
Yeah.
I mean, it's like, how
and
do you
he
do
also
that?
had to file a brief preserving his constitutional issue.
How's he going to know to do that?
And we couldn't. That's the problem. We couldn't. So we had to find someone with an interest in the case. And what we decided on doing was to name as the client, not the defendant, but the lawyers, because there's a list. An assigned counsel list in Michigan, and they go through
like the
list.
public defenders of the appeals.
Yes.
Yeah.
And they get paid for doing these appeals. And if there are more appeals, they would presumably have more money.
Right.
So we had somebody who had some interest, but they were making a claim, and the legal issue involved is called standing. You have to have an interest in the case. But the standing issue was a particular species of standing called third party or jus tertii standing. But that's what we were left with. So we had a two-issue case. The first issue was a civil law question, standing. The second issue was the actual criminal procedure constitutional question of the right to counsel. And I argued the case in the district court, federal district court in Detroit. Victoria Roberts, I still remember, was the judge. And we won. And they took it to the Sixth Circuit. I argued the case in the Sixth Circuit, and I think we lost on both issues in the Sixth Circuit. Well, the brains of our outfit, is certainly in terms of the constitutional question, was a law professor who had recently become a law professor, a guy, absolutely brilliant lawyer named Dave Moran. I don't know if you know him, but he's a professor, a crim pro professor, a constitutional law professor at U of M. And he then took over the case at that point, and we went en banc to the Sixth Circuit, the entire court, and we won. And so we won on both standing and on...
en banc, so for our listeners that don't know, that's like when the court issues a decision, like a court of appeals, right?
The 3-judge panel originally.
3 judges, so you did the 3 judges and you lost. And then they had this special procedure. I have a case right now I was telling you about where they did this, where they then bring in like more judges, right? How many do they bring in? It's crazy.
It depends
it's a lot,
on how many judges are regular on the Sixth Circuit. It's the entire bench, excluding the judges on senior status, basically.
So it's the whole appeals
Circuit.
court.
That's
the whole
correct.
appeals court. Okay.
And we won. And I still remember the deciding vote was by Danny Boggs, who's a very conservative guy, but he went in our favor on both issues. So the case goes to the U.S. Supreme Court. They apply for cert to the Attorney General, and they take the case. Okay, and it's a two-issue case. It's still the standing question and then the constitutional question. I write the standing part, the civil issue. I wrote our briefs on the standing, and Dave Moran, of course, wrote the part of the brief that we were most concerned about, the constitutional question. And there was no question who was going to do the oral argument. I already done that. I didn't want to do it. So Dave was going to do it, but he had to try to master the standing issues that I had briefed. And we go to the oral argument, and Dave gets up, and he starts, and very shortly after he starts, Sandra Day O'Connor interrupts him and says, "You got an interesting constitutional question here, but," and of course her but was about standing, and the rest of the oral argument basically got hijacked on the issue of standing. But the most interesting thing that happened at oral argument was the Attorney General, in his argument, told us, the lawyers who had assembled there, something we didn't know, and that is, he said, there's another reason you don't need to address this case, and that is there's an improper, in other words, somebody who is not represented by counsel, but there's an improper petition for cert pending in this court, in the U.S. Supreme Court.
At the same time.
At the same time, on the same issue. In other words, somebody, the guys we were looking for, who to represent someone who actually was a defendant, had somehow gotten to the U.S. Supreme Court and preserved the constitutional issue. We knew nothing about it, nothing. So what happened was we got done with the argument, and it happened to be the end of the morning call. So the court had left, and we were all at this counsel table, and I think Steve Shapiro was there as well, and we had a bunch of people from Michigan who had been working on the case, and we huddled, and we started talking, and we realized we got to find out about this case that the Attorney General had mentioned in the oral argument. And so two of us were assigned, Mike Steinberg and I.
Mike Steinberg
was the legal director of the state ACLU. Yeah. So Mike Steinberg and I go to the clerk's office, where we are treated royally. This clerk's office was so, like, they were happy to see us. And we said, we're looking for the case. They help us find the case we're looking for. And they said, we said we're looking we'd like to get, this is before e-filing, we'd like to get a copy of the petition and the response to the petition. And no problem. The clerk's office was so gracious and so helpful. And you know me, I'm a torts guy. Really,
yeah.
And I'm standing in the clerk's office of the Supreme Court of the United States and thinking, this is what ambulance chasing at the highest court in the land looks like.
Going to look for clients.
Going to look for a client. And the bottom line on the story was, a couple days later, Mike travels out to a prison in Michigan where Antonio Halbert
that was the guy
serving his sentence. He was enterprising enough. I think he got a copy of one of the briefs we did, and he had used it to preserve the constitutional question without our knowledge. And his response when Mike wanted to sign him up was, "Thank the Lord, we were sent from heaven." And Mike signed him up. And the end of the story was about 2 months after we argued, and the argument, by the way, was early in the term.
You lost the first case with the lawyers, I'm assuming.
We lost on standing. They announced it in December. I think it was December of 2004. And the next month, they granted cert in Halbert. And so a few months later, in the same term of the Supreme Court, the same group of guys from Michigan traveled down to Washington.
And now you're representing the guy that you found.
And now we're representing a guy. We got no standing problem, and they had to hear it on the merits. And we won. Ruth Bader
And so
Ginsburg,
you ultimately won.
Ginsburg wrote the opinion. O'Connor joined the opinion. I think it was 6.
You know, I'm seeing a pattern here. You seem to lose at the United States Supreme Court and then figure out a way to have a happy ending to the story by winning through some other circuitous route, huh?
Yeah. So the end result is I have 3 quills in my desk at the office.
That's exciting. I've never argued at the United States Supreme Court. You know, I mean, I do some appeals, but it's not my main focus. You know.
Yeah, and one of my claims to fame, because I don't do criminal work at all, is I had like probably 4 cases that had a crim pro issue in them, and 3 of the 4 of them went to the highest court in the country. So it's one of my claims to fame, I think.
Yeah, that's a good story, Mark. Well, you know, you have been, I'm sure you've seen the court change a lot in Michigan. I mean, when I first started practicing, it was a very pro-insurance company, pro-business, against injured people, against trial lawyers, against all that.
Now we were talking about the Michigan
Supreme Court. Yes. Yeah.
Yes.
And so, I mean, how was that? I mean, you lived through that. I mean, and it's like, people don't understand, like, when you first start, or, you know, I was like, well, everybody's going to be the same. It's like the same blank canvas. But everybody, judges, a court of appeals, Supreme Court, they have their own biases and, you know.
Yes, there was a period from about 2000 to about 2015 to 2015 where I think you could comfortably say that the Michigan Supreme Court was the most conservative Supreme Court in the country. I didn't canvass all the other courts, but they really were. It was overrun by Federalist Society members. There were certain issues that I was involved with. As you know, there's a 2-step process in the Supreme Court. You have to ask them to take a case, and if they take a case, then you have briefing, and then you have oral argument. But there were a number of cases that I handled in that time period in which, if they granted leave in the case, I knew I lost.
Did you feel like you were hitting your head against a wall, or like, well, they say peeing into the ocean, you know, or I mean, like, what was that like? Well,
it was just, you knew it was pointless. You knew you were going to lose. Like, certain things you could play with them in terms of like statutory interpretation, because as you perhaps remember, they were as literal as anybody could be, literal to the point of being absurd, but that's what they were. They were literalists, and you could at least play on their field and try to be as literal as them and try to win the case. But there are certain common law questions, for example, duty in negligence cases, okay? And I had a number...
You had the Lowecki. Well, ultimately, I guess that was your vindication at the end, right? Because it was, what was the case that was before that?
Yeah, it's the Tort case.
Tort case,
was before it.
Tell our listeners about the Tort case. Okay. Wasn't that the...
the Tort case. The Tort case was a situation in which a woman slipped and fell in a parking lot. Okay. She sues the parking lot owner, but she also sues the snow removal company. Okay.
Because didn't the guy like sleep in and not mow
he had a contract that said if we get X number of inches of snow, I got to shovel the parking lot. And they got X number of inches, and he didn't shovel. Okay, and she fell.
I'd be kind of annoyed, like as a homeowner, if I'm paying somebody if I'm saying, look, I want you to be able to shovel my sidewalk, and I leave for work, and then somebody falls, I'd be like, wait a minute, you know?
Yeah, but what happened in Tort, and Tort was a defensible decision because the plaintiff had to establish that there was a duty to the components of a negligence case. Complicated, simple thing.
From the snow plow removal company.
That's correct.
Right?
And her claim of duty was basically they didn't act on their contract. Okay, they failed to act on their contract. They breached the contract. Now, the contract obviously
But
was not
she didn't-
between the woman and the snow removal company. It was between the landowner and the snow removal company. Okay, so her duty claim was problematic from the beginning, and it was problematic because what she was suing for was a failure to act. And in negligence law, it makes a huge difference if you are suing somebody for failing to act, because whatever people understand about negligence law, the one real sticking point for a plaintiff is it's very rare that you can sue somebody for failing to act. Okay?
So by essentially suing them for not doing anything,
That's correct.
as opposed to doing something
For
really
what
badly.
they did,
Yeah.
for what they actively did negligently. Okay, so Fultz was, in my opinion, not necessarily incorrect, but what happened is a very sloppy Supreme Court, very conservative and very sloppy, ended up writing a couple of these orders, very short orders, okay, which suggested that this contract thing that they talked about in Fultz might also apply to situations in which the defendant was actually engaged in affirmative conduct.
Like what? Like, give us an example. Do you
Well, there
remember?
was one of these orders involved one of the airport, not elevators, those walking, those,
The escalator things?
not escalators, but the
Oh,
things that
like the moving sidewalk things.
exactly.
Yeah.
And there was something they actually did to the moving sidewalk that made it dangerous. So it was an active negligence, not something they failed to do, active negligence. Unfortunately, the Supreme Court said it was a Fultz case. So what developed from these cases, largely from these stupid orders that the Supreme Court wasn't thinking very much about, was the defendants picked up on this, and they started to develop this idea that if you were engaged in a contract, if you were just engaged in a contract, you had some sort of immunity from tort, even if you were affirmatively acting. Just an utterly dumb position. But it started to get traction, and it started to be adopted in several Court of Appeals cases. Okay, so they finally took one of these cases. The name of the case was what you mentioned, Lowerkey. And I wasn't hired to do the brief in Lowerkey, but I did a brief for the Michigan Association for Justice. I did an amicus brief. Well, the plaintiff's lawyer in Lowerkey saw my brief. I think he correctly assessed that it was a little better than his brief. And so he hired me to do the oral argument.
See, that's smart. I got to give that person credit, because a lot of times people will not do it, and we were talking about this before. There's nothing worse than having somebody who shouldn't be before the
Yes.
appeals court, a bad lawyer, an unprepared lawyer, maybe just not experienced, not knowledgeable, whatever, but then argue these cases, because you're not just losing one case, Mark. You're losing the whole thing for everybody,
That's correct. Now, I have to say, in Michigan, there really is a dedicated appellate bar, people who are really, Mark Granzotto, for example, who are really good at it, okay? And most plaintiffs' cases, it's the first question I ask when somebody says, oh, they granted leave or they granted oral argument. I want to know, who's the plaintiff's lawyer, okay? And if it's somebody I don't know, I get a little concerned, okay? Because obviously you're correct, they're making law for a lot of people, not just one. And it's a big deal, but usually in Michigan, it's somebody experienced going to the Supreme Court. Yeah, but I was very satisfied. In fact, I once had a post-Lowerkey argument in the Sixth Circuit where I described my oral argument in Lowerkey as one of the most satisfying I had ever experienced, because I had begun my amicus brief in Lowerkey with a hypothetical, a completely outrageous hypothetical, which was like it showed the extension of this.
How crazy it was.
Well, it was a guy who's told by his wife to go buy a loaf of bread, okay? And he, before he leaves, she makes him sign a contract that he's going to, for X amount of money, going to buy a loaf of bread. And he drives away and he runs over somebody in his car. Okay, outrageous to think about it. But based on this extension of lower key, okay, it was something that the defense was basically, oh yeah, he's immune from tort. And the one really rewarding thing is I began my oral argument in lower key with the same hypothetical. And I still remember Ernie Bazzana was my opponent, and Ernie from Plunkett Cooney, he was the biggest practitioner of this contract immunity question. And he was advocating it. And we had at the time 2 liberals on the Supreme Court, one of whom, Marilyn Kelly, was not usually a vigorous participant.
Yeah, I clerked for Marilyn Kelly.
Okay,
yeah.
She's very nice, but she wasn't usually into the repartee associated with oral argument. But to her credit, she must have read my amicus brief, okay, and she was persistent for the very first time. And I was so pleased because she kept asking Bazzana when he was up there, what about this hypothetical with the loaf of bread and running over these people? And she persisted, and Bazzana did not want to answer. It was so funny to watch because you knew what his real answer was. His real answer was, oh yeah, he's immune from tort for running over this innocent pedestrian. But to her credit, I was so pleased in that argument with Marilyn Kelly because she wasn't always so persistent, but she finally got him to say what I wanted him to say. It was a great argument.
So tell us about lower key. So didn't they put? That's okay. Oops. Didn't they put a sheet metal or some construction item?
That's correct. And the big difference in lower key is they had done something. They arrested some...
Was it like a construction worker
That's
or something?
Correct. It was on a construction site. But the key thing was they put it there in a dangerous, precarious position.
What was it? Like a big piece of material?
Yeah, it was. I don't even remember exactly what it was. But
and I think it was boards or something. And it fell on some dude, didn't it?
Somebody.
And crushed some guy.
And the big difference between Fultz and lower key, and a humongous difference for purposes of Michigan negligence law, is they did something and they did it wrong.
They took the material and they leaned it up against a thing at a construction site that was dangerous. And you won that case.
And the other thing about the case, it might be a one-off in Michigan law, but because of changes in the court and retirements or something like that, the final vote in lower key was 4-0.
Oh,
in
wow.
a 7-member court. I don't think it's ever happened before.
That's amazing. Yeah, but they were using that on all kinds of cases. I had cases. I had a kid who sat on a stool and it poked his urethra out. That was. They said, well, the cleaning company that's responsible for maintaining isn't responsible.
I worked on that case.
You did work on that case. We lost that case, unfortunately.
That's right.
We had. I had a case where a door frame collapsed on a little kid's head. And they said, oh, we're not responsible for the door frame because we didn't do anything to it. We just watched it decay over 20 years. It was crazy. It was crazy.
Yeah. So
it was crazy.
A failure to act is still definitely a problem for plaintiffs' attorneys. There are some exceptions, for example, in the Med-Mal area, because of the relationships between healthcare providers and plaintiffs. Failure to act is still actionable in malpractice. It's where I see it by far.
Let me ask you a question, because I got a case right now that's at the Court of Appeals. All right,
Good.
So some free appellate advice
Good.
on the show. My guy was working at a loading dock. okay, that these big Chrysler trucks would come in and out, and they would dump from all over the country all these Jeep Grand Cherokee parts for the Chrysler plant in Detroit. Okay. So like rear view mirrors would get dumped out, whatever, all this stuff. Then they would sort them in this facility, and then when the Chrysler plant needed the parts, when they ran low, they'd call over and they'd run all the parts over. So it's like a distribution thing. Good. So they have these huge bays. They have like, you know, maybe like 80 to 100 bays at this warehouse that these big semis pull up to. And when the semi pulls up to a bay, they have to get connected to the bay. So the way they get connected is there's this massive industrial metal ramp that raises up. The truck backs up, then the ramp goes down, and that allows the high-low drivers. It creates like a bridge in between the warehouse and the truck. So we sued.
What happened?
So yeah, what happened? Yeah, I almost skipped over that. Before we sued, these bays were like so decrepit, and like these these semis are like running into these ramps. Sometimes they're falling apart. They don't get fixed. The company hired there's a company that actually works on these ramps. That's what they do. And they said, look, we don't know shit about these ramps. We just know that they're not working. You're in charge of the ramps. You got to inspect them, fix them, whatever. So this company doesn't do a good job of it. This ramp keeps breaking. It gets jammed. My guy tries to move the ramp up and down, and the springs break, and the whole ramp just comes crashing down on this dude's foot and smashed his foot into like a pancake. Okay, because these ramps are like thousands of tons or whatever they are. Okay, I don't know. They're a lot of hundreds of tons, whatever. And so we sued the premises owner, said they're your ramps that you had installed, you got to fix them. We sued the products manufacturer, said you made a bad product. And then we sued, I thought the best case was going to be against the people who were supposed to be looking after these ramps, right? That's supposed to be fixing them. We won the case against the products manufacturer. We won the case against the owner. The judge dismissed the case against the repair company, saying they didn't have a duty because they were contracted to repair these ramps, yes, but they just didn't do what they were supposed to do. And so because they didn't do their contract, they're immune from suit. So again, this is kind of like a failure to act. What do you think about that case?
You read the classic Tort handbook, Prosser. It makes note of the fact that there's a very fine line between acting and failing to act. And the obvious argument that's available to you is associated usually with one word, undertaking. When you're engaged in an undertaking, okay, that's acting. That's actually performing an act, and that's certainly the argument I would make in your situation. They're undertaking the repair of that. That's not a failure to act. That is a negligent performance of an act. I mean, that's the way.
Yeah, that's a good argument. There's a case, were you on this Leon case that was in the federal court?
No.
There was a case where like there's a chimney stack at like one of these steel plants, and the chimney is full of bricks. For some reason they line it with bricks on the inside.
Whose case was that?
I don't know. I was wondering if it was yours because I cited this case.
Yeah, it might have been.
It might have been yours. So they like this company had to come in like once a year, go inside the chimney, and then they had to like seal all the bricks because these bricks would like start decaying and then they would fall off. Well, the company came in, they didn't do a good job, and some dude's working under the chimney and a brick falls off and hits him in the head and like seriously injures him. And they said that was the case. So,
Yeah. Did that make it to the Sixth Circuit?
Yeah.
That was my case.
Yeah. So I cited it. Good job. This is why we need. Yeah. This is good. Thanks.
I'm
Thanks,
not really
Mark.
good on names.
Yeah, that's okay. Neither am I. Well, I'm being told we're out of time. So it goes quick, doesn't it?
It does go quick.
It does go
You ever do oral argument in Cincinnati? 15 minutes? It goes real
Dude,
quick.
I have. It was a harrowing experience. I walked out of the Sixth Circuit, and I never feel so used and disabused in my life.
Very funny.
But yeah, man. Well, this was great. Keep up the good work.
Thank you.
It's good.
Was this okay?
You did great.
Okay.
You did great, man. And you know, it's very interesting because it's a whole different area of the law with its own little rules, quirks, and its own little world.
Yes,
you know,
it's true. I mean, his wife had a job for 40 years.
Yeah, well,
it's a different world.
Thanks for fighting. You know, through the. I always say now, it's people now are the tides are shifting. You know, we get all these calls like, "Oh, I want to be a plaintiff's lawyer." You know, John Eads just joined me. Great guy, great friend.
John.
But you know, now everybody's like calling, like, "Yeah, we want to be plaintiff's lawyers." I'm like, "All right, you guys, especially the younger people, don't." Unless you've made it through the dark ages, you know, you guys have it easy. I sound like an old curmudgeon, but you guys have it easy now compared to what we had to deal with. But you especially, you know.
Yeah, it's going to be 6-1 Democrat to Republican, and it was at one time, as you know, 5-2 with 5 Federalist Society members on the Michigan Supreme Court, as conservative as you could imagine.
All right. Well, thanks, Mark.
Okay.
All right, everybody. Thanks for listening to today's show. And thank you to Mark Granzotto for coming on the show. If you or someone you know needs help, whether it's an appeal or other type of things, don't forget to reach out. We'll get you connected with Mark. He's a great attorney. You can go to our website, markolaw.com. That's www.markolaw.com, or give us a call at 833-MARKO-LAW. We'll see you in another 2 weeks for another Cases Gone Wild.